Ma'am, we are live. Let's start. Good evening and warm greetings to all. I, Sakshi Agarwal, welcome you all for today's session on the topic Contours, Constitutional Contours of Equality for Women in Services. It is really a golden opportunity and moment of pride for all of us to host Senior Advocate Aishwarya Bhati as a guest for today's topic. Ma'am has been instrumental and played an important role in the bringing permanent commission for women in army. She is the first women advocate from Rajasthan and is among six other women advocates who have been designated as senior advocates. She has served as secretary to the Supreme Court Bar Association and was appointed as the additional advocate general for Uttar Pradesh in the Supreme Court in 2017. Now, without further ado, I would like to invite ma'am to commence the discussion with the insights and inputs on today's topic. There you go, ma'am.
Thank you very much, Sakshi. It's indeed a very proud privilege for me to be sharing my thoughts, my experiences, my learnings of as a student of law who has been practicing law. And Constitution is a topic of great importance. It automatically becomes, if you are a student of law, you start reading the Constitution and you start seeing the play of Constitution at work and how it is operating itself, and you more and more. It is, of course, always a love at first sight, and then that love at first sight blossoms into something stronger, and it becomes a relationship for life for any student of law. So I'm happy that you assigned to me a topic which has contours in both things. That one is my identity as a lawyer, as a woman, and at a cross section with something that I love a lot. Constitutional equality. I think we are all very lucky to be in the proud nation. We've just completed 74 years of independence, and as a proud nation, for us to be celebrating our constitutional principles and equality even more is something that I should credit you for giving me this opportunity. So the topic that is assigned to me is the constitutional contours of equality for women in services. I'm going to take you briefly through some of the constitutional provisions which have been instrumental in sort of magnifying or allowing that equality to blossom, to flourish, setting the background and the platform for it at one place, and then allowing it specifically, having the right kind of circumstances and nurturing environment for that equality to flourish. Of course, it's a work in action. It's not something that we have attained or arrived at and we can rest on our laurels. No, we just 3 days back we have had a emphatic pronouncement by a larger bench of the Supreme Court, allowing at par rights to women as co-partners, as male co-partners in the ancestral property, irrespective of when the father or the karta or the senior co-partner whose property we are talking about, that person had died. So it is certainly a work in action. One, I'm going to speak about some constitutional principles. The second aspect of my conversation would be with regard to how they have been interpreted in the courts of law. So let me start with what we started with. When India started its march as a young democratic republic 74 years ago, we all know that our founding fathers did an exercise which was a very comprehensive exercise. For that reason, our constitution is often known as amalgamation of best practices of the world. It's laughingly even called as a bag of borrowings, because what our founding fathers did for our constitution was to assimilate and take actually the best practices of the constitutions from across the world, whether it was the unwritten constitution of the United Kingdom, the colonial power from which we were gaining our independence, or it was what was respected as the world's oldest and most developed democracy of the United States of America, or the cherished hollowed principles of liberty, justice, equality from the French system, from Australia, from Europe, many countries. It is actually, that's a different, completely different topic if we start going there from where we have taken it. But it has something from everywhere, and those were understood to be best practices. You'll find it interesting. I often remind this to my colleagues when I'm speaking about women related issues. I think it's also important to see where we have started from, or where we have been in the last 100 years, and where we have arrived. If we see it in perspective, it is easy for us to appreciate it. You all would have noticed just 2 years back that the newspapers were full of 100-year celebrations, centenary celebrations of women having got the right of adult franchise in the United States of America, the so-called the world's oldest, most powerful democracy. Um, but it's surprising that it has just been 100 years that women were granted the right to vote. Even there, it was interesting to see that the racial struggle managed in a right of vote for the colored people there faster than women were able to get. Though we have seen that so much of ado has been made about the racial struggle, and rightly so. But women were able to get a right of franchise, and franchise is a very important right, my friends. Don't just understand it as just a bare right to vote. Sorry, the bare right to vote has in itself a multitude of rights. It is, if we don't have a right to vote, it actually amounts to our political, social, financial emasculation. So it completely disenfranchises us from the way our countries run, what our rights and duties are. If those are not at the forefront, if we cannot have access to any of those rights of governance for us, or the all the lawmakers or the executive or the legislature does not, for them we are not even there in the in the scheme of affairs for consideration, then it is a very difficult proposition. Now, imagine that 102 years back, this was gained by the democracy which is hollowed as the most developed democracy. 74 years back, when our constitution started to come into form, the founding fathers set up the Constituent Assembly and the constitution was being made. There was a choice with our constitution whether to start from the beginning, or whether to already have all this ingrained. So it is very important for us to appreciate and understand all that we did not have to struggle for, which was a huge struggle for countries, for other countries. I will also mention here briefly that before the 18th century, rape was not considered as a crime against women. Never it was understood till 18th century. It was understood as a crime against property. It was considered as a crime against the father if the woman was unmarried, and rape was considered as a crime against the husband if the woman was married. And that is why, if you remember, the definition of adultery, which was held to be unconstitutional about 5 years back by a constitution bench of our Supreme Court. That definition of adultery legitimized that relationship with a married woman if that relationship was with the consent and connivance of the husband. So just imagine, if a extramarital relationship with a married woman is with the consent and connivance of her husband, she's immaterial. She's neither a victim, she's not an accomplice, she's nothing. She's nowhere in the scheme of affairs. So if it is with the consent and connivance of her husband, then it is not even an offense. That is how it was worded in the IPC, and that is why, of course, it took a long time for the Supreme Court to realize that um, how it glorified women as chattel of men. But that is the preface. Sorry, I've taken a little extra time with the preface, but I felt that it was important to have that preface. Um, Sakshi, I'm going to take about 40 minutes, and then we can have an interaction. That's how I'll go. Just keep a time, timeline for me, please. If I
Yeah,
start,
sure.
thank you.
Yes.
So when we started, our constitution had there was no problem with the universal adult franchise. There was no problem with equality. It was already there, so we hit the ground running. The issues that women across the world had been grappling with was never an issue in terms of our constitutional principles. Now let me start with some of the important provisions which are there in our constitution. So I think the most splendid part of our constitution is, it is, of course, it used to be world's longest constitution till Yugoslavia exceeded that uh, uh, that uh, uh, title from us. Of course, then Yugoslavia itself broke, and I think the topic is back with the title is back with us of being the longest constitution. So, as the longest constitution consisting of about 400 articles, more, in fact, more, though in numbering it is only 395, but then there are so many ABCs and parts in between. So, divided into 22 parts and consisting of 12 schedules at the back of the constitution. The most significant thing about our constitution, I feel, is that the constitution does not, and it's an exhaustive constitution that deals with how the legislature would be at the union, the executive, the judiciary, how the provisions are going to be at the state level. It talks about panchayats, municipalities. Of course, that was brought in by the 73rd constitutional amendment. It talks about the union territories, the tribal areas, the relationship between union and legislature, the finance, property, contracts, and suits. It talks about trade, commerce, laws within the territory of India. It talks about the services under the Union of India, public service commissions, tribunals, elections. So, very, very exhaustive constitution we have. Official language, emergency provisions, special directives, miscellaneous, temporary and transitional provisions. I'm just going through the heading of the parts that are there, the 22 parts, some of them. What is most spectacular is that uh, no part has been kept away from women. So there is no segregation, there is no separation, there is no discrimination, there is no even compartmentalization that has been made to keep something away from women. That usually is the most convenient thing to do. Oh, this is just not the woman thing. So the constitution from the word go did not make any separate compartment where women did not uh, could not enter or could not aspire to enter. And that is one of the most important achievements of the constitution. The second achievement being the universal adult franchise. Everyone in India, irrespective of their caste, creed, religion, race, gender, most significant gender, because that was a battle that women across the world were fighting at that time, and they were allowed that. The third important aspect for the constitution as a platform was equality. So Indian constitution recognizes equality in a very beautiful manner, where equality is not just prescribed in letter and spirit, and equal protection of laws is available to everyone who's in India. It is also interesting that in public employment, equal opportunity is available to all. And it goes a step further for women, for children, for certain other disadvantaged classes of people who were found fit by our founding fathers because of decades and centuries, really not really decades, but centuries um, uh, of oppression that they had meted out with, because of centuries of unequal power play between them. So those categories, there was something that was identified as affirmative action. That affirmative action actually takes it a step further than equality and makes sure that equality as a principle is available for as equal treatment of equals. Now, under Article 14, which is the general principle of equality, it is very clear that equality is available. There'll be equal treatment of laws. Everyone is entitled to equal treatment of laws under our constitution. But what is interesting is the Article 15, Article 16, which are equally part of the right of equality, and they speak about the state being empowered to make special laws for women, children, etc. Those categories, specifically women for our consideration today. Uh, because they had been disadvantaged for those centuries, so it was important. It was felt important that special laws could be made for them to actually bring them at par with the equals. Because if you treat equals equally, it is equality. But if you treat unequals equality, unequals equally, then you are actually perpetrating inequality. That is how the equality principle is understood in our constitution. So it was felt that women, for certain areas and certain issues, were not at par with men. And if they are not at par with men, then it would actually, if it was equally applied to everyone, then it would actually amount to giving them, perpetrating inequality among them, because they were unequals to start with. So that is the important concept of equality that we need to understand under Articles 14, 15, and 16 of the Constitution, where equality is categorically enshrined. But along with equality, it is very, very strongly said that uh, laws, specifically under Article 15, that nothing in this article shall prevent the state from making any special provisions for women and children. And that is how you see in a lot of areas special laws have been made, uh, whether it is to curb crimes against women, specifically dowry related laws, bride burning laws, laws to curb domestic violence, for harassment. In fact, if you notice, before the Nirbhaya judgment, before the Nirbhaya tsunami became a revolution in the society, IPC only had two specific separate offenses for women. One was outraging the modesty of a woman, and the second was the rape provision under uh, the rape provisions. It was in different classifications, but essentially rape. After the Nirbhaya amendments were made in our IPC and the other criminal laws, other offenses came to be added: acid throwing, voyeurism, stalking, eve teasing, sexual harassment. All of these were added as specific offenses under the Indian Penal Code. And these offenses earlier used to be understood as offenses which are lower in their magnitude, which have lesser impact. But it was realized that these so-called innocuous offenses against women, when they remain unchecked and unactioned, that is when they snowball into the bigger offenses against women. And interestingly, in all of these offenses, a further distinction was made that first time offenders were, the sentence for first time offenders was smaller in all of these offenses, and the sentence for second time and multiple offenders was much bigger. And it kept on going up if as the um, offense was repeated multiple times. Now, I must also mention here, POXO was a law that was made in 2010, which is the Protection of Children from Sexual Offences Act. That was also under this act, but it covers. It's a gender neutral sexual offence law, which is specifically for the benefit of children. I also have to give you an example of the dowry laws, specifically the bride burning laws, uh, because what the bride burning laws have done by specific provisions in law is they're actually a departure to the regular criminal jurisprudence of adversarial system that is there in our country. So in India, crimes have to be established beyond the shadow of reasonable doubt. We don't follow the European inquisitorial system. We have adversarial system where any crime has to be established beyond the shadow of all reasonable doubt. Now, what happens is that uh, it was seen that the crimes which were like bride burning kind of crimes, which were happening in the four walls of a matrimonial home, there was very little evidence that was coming in to actually secure a trial and a conviction under the rigors of the criminal jurisprudence that was required to establish it beyond the shadow of reasonable doubt. I mean, that house is surrounded by friends and neighbors of that family, and when the family gets together against that young bride, that is when bride burning happens in those village in those households. It's not a village thing. This unfortunately continues to happen in the heartlands of our country still. Our system is still grappling with the crime of bride burning and dowry deaths in a very real sense. So the legislature made laws which was a departure from the system, and it allowed that for dowry deaths, if the four or five conditions are met, namely that the marriage took place just 7 years prior to the death has happened under unnatural circumstances within 7 years of marriage, there was a demand of dowry from the husband or any of his relatives, and there was cruelty with regard to that demand of dowry on that girl, on the girl, soon before her death. If these conditions are met, then the onus of proof actually shifts on the matrimonial home, on the accused in the matrimonial home over there in the house, to establish that it was a natural death and it was not really a case of bride burning. So this is a clear departure. And if you see, there are several other cases also where a complete onus shifts on the other side. Once the minimum conditions which are there are meted out, the onus moves on the other side. This was felt necessary to protect the rights of the women. One another example that I must give is also the law that was an outcome of a Supreme Court judgment of Vishakha in 1996. Supreme Court laid down guidelines to curb sexual harassment of women at workplace. Justice J.S. Verma, who was heading the bench at that time, laid down guidelines. And usually, Supreme Court does not lay down law. They assess, they consider, they uh, they see whether the law has broken the constitutional parameter, and the law is declared to be constitutional or unconstitutional depending on whether it falls in the parameters of the constitution or not. But it is never the job of the Supreme Court to lay down law. But in this case, the Supreme Court made a departure. It was again a very heinous and grievous facts that compelled the Supreme Court to do this. Bhamri Devi, who was a Sathin in my state, the state that I come from, Rajasthan, she was a Sathin who was a social worker at the village panchayat levels, and she was trying to stop child marriages which were happening in this high class, high community household in the village. She managed to stop those child marriages, but she had to pay back, and she had to pay by the multiple men of that community, that household, that high class society community, sorry, not society, high class community, high community, uh, 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 ravaging her with gang rape, just because she had stopped those child marriages which was in the course of her duty. So the Supreme Court took us, of course, the criminal trial took another angle, but an NGO, Vishakha, urged this matter before the Supreme Court, and Supreme Court laid down guidelines and said that uh, till the Parliament makes a law to curb sexual harassment of women at workplace, these guidelines are going to have the force of law. So the guidelines which were laid down in 1996 continued till the law was laid down in 2013. It took that much time for the law to be brought into force. But yes, those are the provisions that have been effectively and emphatically used uh, by the chief interpreter of our constitution, the Supreme Court of India, to ensure that uh, equality is done in the true sense. Now, taking you back to the constitutional provisions, I spoke about the equality rights. Then there is the right of freedoms, right against exploitations. These the rights against exploitation, which are Article 23 and 24, are also very significant rights with regard to women, because it was essentially trafficking of human beings was trafficking. Essentially, a large number of this trafficking was happening um, of women. Article 16 is also very important for our purposes, which I just mentioned but did not labor on further, because this allows equal opportunity in public employment. So when we are talking about women in service, it was important for us to understand. It is important for us to understand that public employment, which is a huge chunk of services that is available for any citizen to join. The constitution from the very beginning prescribed that there has to be equal opportunity available to all citizens in public employment. Other rights in private spaces, it took a little while, but uh, in public employment from the beginning it was there. So the state could not make any discrimination for giving public employment to any of its citizens on the ground of their gender. uh, then one repealed section of the constitution, which is the Article 31, which was the property right, which was available as a fundamental right to start with. Of course, subsequently, the amendment happened, and the land reform laws came. Zamindari or jagirdari tradition was abolished in the country, and that was a social reform that was necessary to give land to the landless cultivators, the tillers who had been tilling the land for centuries without having any ownership on that land. So that time, right to property was removed as a right, as a fundamental right, but it has been safely secured in our constitution as Article 300A. This right also was equally available to all its citizens. So Article 31 did not make a distinction on just men holding their property and having a right. It was every citizen having his property had the right on his property, and he could not be deprived of his property save by the authority of law. That was the language um, of Article 31, which ultimately now finds place in Article 300. Uh, then, of course, I mentioned, I mean, we could go on and on forever to say that many of these articles did not create a boundary for women. One such very important article was Article 32, which allowed constitutional remedies for enforcement of fundamental rights. And this right also made no distinction, but it was significant in that women um, could be petitioners in their own causes, and actually, uh, whenever their fundamental rights were either violated or threatened to be violated in any manner, then they could go to the court of law. Now, directive principles of state policy are more have had very significant impact on uh, the other aspects. I would say the secondary aspects of women in service, which are very very significant. So part three, what we saw so far, was with regard to laying the foundation. It was like creating the platform and making it ready for women to step on it. But the directive principles of state policy, which is there in part 4 of our constitution, and the whole purpose of putting these rights in the directive principles of state policy was because when India was becoming an independent country, as a young nation, we did not have the wherewithal to have all our aspirations realized from the day one. So part 4 was formulated so that the state could formulate its policies, its governance, uh, in this direction, to ensure that this is the direction that our founding fathers wanted our nation to be taken towards. some of these rights which are there in the directive principles. So some of these directive principles, in fact most of them have now uh, uh, been made into formal laws, statutory laws, and those laws have actually ensured that there is equal protection, there is equality in a better sense. And this I'm going to take you at some length to also see the impact of it. Right. So the directive principles of state policy, specifically to start with, first I have to take you to Article 39A. Now, Article 39A, uh, Article 39A is with regard to equal justice and free legal aid. This is in part 4 of our constitution, and free legal aid is something that has come for women as a huge right, because legal aid is now available in a statutory form in the through the Legal Services Authorities Act of 1987. There are legal aid services authorities at the national level, which is headed by the Chief Justice of India. At the state level, headed by the Chief Justice of every state. It has senior judges, district judges, senior advocates. This whole mechanism is created, and I'm happy to tell you that this has become one of the most effective mechanisms to allow women have access to courts for any violation of their rights, whether fundamental rights, constitutional rights, service rights, employment rights, all rights. And for all other classes, you have to show your economic capacity. You have to be below economic capacity to be able to avail of free legal aid. But for women and children, legal aid is available free of cost, just because it's a woman or a child who needs to have recourse to the court of law. So, and now legal aid clinics are not just available at the higher level. Legal aid clinics are available in every district court of the country. In fact, now many munsif and taluka courts also have these clinics available of legal aid, where consultation, opinions and legal action all can be materialized uh, for so legal aid was a very important right that was granted. Now, Article 39 before that is something that is very, very significant for women, because Article 39 said that the citizens, men and women equally, have the right of an adequate means of livelihood. Uh, then it says, Article 39, small d says that there is equal pay for equal work for both men and women, that the health and strength of workers, men and women, and tender age of children are not abused, and that citizens are not forced by economic necessity to enter avocations unsuited to their age or their strength. So these three articles which are there in Article 39, giving them right to adequate livelihood, giving them equal pay for equal work. See, this is a struggle that women have had to had, again, not just in our country, but in countries across the world. It has always been felt that women are inferior workers, so they are not entitled to equal wages as men do. And this has been a huge disparity, and this disparity was attacked and addressed by our constitution, which ultimately resulted in a law also being framed. So now this is securely present as a law, and the Equal Wages Act makes sure that there is equal wages available for all men and women. And any woman who is in a job can actually pursue a litigation if she is not given equal wages for the equal work that she is performing. Of course, the harsh realities still remain, but in law, in constitutional provisions, that equality was strongly given. Uh, what is also very important is Article 42, because Article 42 specifically said about humane conditions of work and maternity relief. I will tell you how important this is, from my own example. So Article 42 says that state shall make provision for securing just and humane conditions of work and for maternity relief. So often it happens that okay, a woman has been included in the workforce, but now what to do? She's going to have these biological duties, biological her body will go through it. She will become a mother. She will have her maternity duties. How is that going to play out? That has been a huge deterrent and a huge disadvantage. In fact, when I talk about the judgments, though we are running short of time, I can see I may not be able to elaborately take you through judgments, but some of the early judgments that the Supreme Court was grappling with for on issues of gender justice. In one case, in the 60s, the Supreme Court was considering the constitutional validity of a condition of service in an all India service, which required a woman employee to take permission if she was getting married. Now, this requirement was not there for a gentleman officer, but gentleman employee, but it was there for a woman employee. If she had to get married, then she had to take permission of the employer. This was struck down as arbitrary, as unconstitutional. We all know that this Air India case, the Nargis Begum case of Air India. Air India used to have a policy of terminating employment of women air hostesses as soon as they became pregnant. That again was struck down by the Supreme Court, and they said this cannot stand the test of constitutional ethos and constitutional principles. But that is the kind of battle that women have to undergo now. You have to bear in mind that a working the graph of a working person and the graph of somebody wanting to have children, those are graphs which happen simultaneously. They go together. It's not like you can set up your work or profession or your service and get established there and you can have your children later. There is a specific timing when it is best biologically also when you should have children. So this is something, a problem that we have seen even in our courtrooms. uh, you know uh, uh, till 2014-15, there was no creche that was available. That was not part of the statute. That was not thought of, and it was felt that, oh well, it's a woman's problem. She has to handle it. I mean, if she chooses to have a child, it's her problem. It's her choice. And it was almost like giving women this choice that either be at the workplace or have a child. Make a choice between two. This is not an easy choice. How come this choice is never thrown at men? But this is never an easy choice, I can tell you. Even if you are a strong professional who wants to do something with and realize her aspirations in the professional area, no mother can take this decision to leave her children to be in the profession or the service at the expense of the children. So though it may seem like issues which are not so significant, that maternity leave, child care leave, availability of creches in workplaces, but these are very significant steps to actually empower for women to be there as equal part of the workforce. So Supreme Court also did not have, and it was effort of many women lawyers and many judges, but it was able to fructify at the time when I was the secretary of the Supreme Court Bar Association. And in 2014-15, in fact, Chief Justice Dattu was the chief of Supreme Court that time, and we did not have adequate infrastructure at that point available, but arrangement was made. Rather than putting it away till we could have a permanent building, an arrangement was made in the chamber block, and two of the chambers were converted to have creche for women lawyers, women employees in the registry. Of course, judges are they they are older, so they don't need to they don't really have children of that age who need to be tended in the creche. But this facility was made available. Before this, many of my friends Of course, my journey of how I have brought up my children is altogether different, but I have seen many of my friends bringing their children in the cars to the parking in the Supreme Court, coming to attend their cases, going up to do their cases, going back to attend to their children, to arrange for their feed, etc., while the children would be waiting in the car. So it is a very, very difficult proposition. It's a very difficult journey, and it becomes very difficult for working women if they have to be asked to make a choice. Another important right in the directive principles is for the state to promote with special care educational and economic interest of weaker sections of the people, and to protect them from social injustice and all forms of exploitation. uh, Ultimately, life and society is also, we are also governed by laws of nature, so it is pretty much like National Geographic, the way we see it in real world. In the National Geographic, you will notice that it's, whenever a bigger animal is looking for a prey, is getting ready for a hunt, he identifies that in that the group that he's looking at, he's eyeing that group who's more vulnerable, and invariably it's the children, the infirm, and the women, those kind, because they are smaller animals, they are so they become the easy catch for the prey. It's the same way, and therefore whenever there are constitutional rights which allow for special care and special educational and economic interests to be taken care of the weaker sections, the women automatically have a very important positioning in that. Article 51, capital AE, specifically talks about to promote the state to promote harmony and spirit of common brotherhood against all the people of India, and to renounce practices derogatory to the dignity of women. Apart from that, I mentioned the panchayat provisions. That was the 73rd constitutional amendment. We have seen that in the panchayats, one third of the seats. So there is a reservation for women in the panchayat level, and one third of the seats are reserved for women in the panchayats. Of course, not much has happened from there, because there is another phenomena that I was speaking about recently also, that in Rajasthan there's a new nomenclature of somebody who's known as a sarpanch pati. So sarpanch pati is the husband of the sarpanch, because the seat is to be only reserved for a woman sarpanch. So she becomes the sarpanch, but she continues to wear her gungat and sits on the floor, while her husband sits on the chair which is meant for the sarpanch, and he's known as sarpanch pati, and he runs the panchayat. But the social inequalities will remain, and that is a barrier that we have to fulfill. We have to bridge that barrier, and that bridging of the barrier has to start from us, from me, from my family, from my daughter, from my son. And because ultimately the nation consists of us, of small families, and the most primary unit of the nation, of societies, is the family. So that bridging has to happen from us. But we have seen that all of these directive principles have now, not now, I mean, the Minimum Wages Act is of 1948. Then there is a scheme which mandates cash entitlement to each pregnant women. The Maternity Benefit Act is of 1961. Of course, now we have seen that the maternity leave has been enhanced. The child care leave has been enhanced, and now that is equally available to all. The various schemes that are also of the government in terms of these statutes, whether it is Janani Suraksha Yojana, Surakshit Matritva Abhiyan, or even Narega, Mahatma Gandhi Narega scheme, to encourage women to continue gainful employment under that, is something that has paved way for women to realize their constitutional rights. With regard to women in higher education, the UGC has had specific schemes of women specific colleges, women specific universities for a long time, and these colleges and universities have ensured that women are, women have now broken all barriers with their professional education, whether it is whether it is qualified professional streams, space programs, scientists. I mean, look at our Mars mission, the mission that has made India proud in the entire international community, was actually propelled by a team of women scientists. So these were areas which were unheard of for women in the beginning, but it is these constitutional guarantees which have been converted into laws, which have allowed for women to realize their aspirations, contribute in equal measures. And actually, it's sometimes we forget that when we talk about women's empowerment, we feel that it's a battle between man versus woman. It is a wrong way to look at it. The battle is not between man versus woman. It's not a he versus she battle. It is a he for she. That's the battle we need to focus on. The battle is really with the patriarchy, with the mindset of that stereotype. I will end with that judgment of recent judgment of mine, where women in the armed forces, I did have the privilege to represent some very, very courageous and uh, you know brave women in uniform in the Indian Army, in the Indian Air Force, and in the Indian Navy, all three arms, all three services. And these women had been battling for equal opportunities of command positions in the army, of permanent commission, on equal opportunities with the gentlemen officers. And they were facing the same kind of battles. Even at the time of final arguments before the Supreme Court, the arguments that were raised by the army were ranging from, their physical standards are lower, and they have their biological and their maternity responsibilities put them on a disadvantage to be effective soldiers in service of the nation. And the men that they command are from that rural background, so they will not be able to take command from women. And such kind of excuses that were made. But the bench, I'm happy to tell you that the bench of Honorable Justice Chandrachud and Justice Rastogi completely slammed those arguments and said that this is a battle of the mindset, battle of stereotype. And there is no place for these excuses in our constitutional framework, and women are entitled to at par opportunities of permanent commission, of command positions. So that judgment of army was followed by a judgment for the naval women officers in quick succession. The Air Force matter is still pending, but it has been a long battle. I think I've overshot my time a lot. We'll talk about the judgments and the interaction if it's convenient. Let's have now interaction. I've spoken for far too long. Thank you very much for hearing my thoughts. You're muted, Sakshi.
Thank you so much, ma'am. Ma'am, we have a lot of questions in the chat box. So I hope the questions are visible to you.
No, Sakshi, where do I see them?
The comments section, ma'am.
Why don't you pick up questions and tell me?
Yes, ma'am, I'll do that. Ma'am, the first question is from Ankit Sachan. Today, the wages or payment difference owing to the gender bias is still a serious concern. How should legislation and judiciary move ahead to tackle this challenge?
So, Ankit, you are right. When I mentioned the equal pay for equal work and the Equal Wages Act, which is a very old act, uh, the problem is that in India we don't have a dearth of laws. In fact, our laws are amongst the some of the best laws in the world, uh, mm, ensuring that the equality is realized in the true sense. But the ground situation still remains quite abysmal. In fact, the ground situation needs to be corrected at multiple levels. So the ground situation still is that, especially for unorganized sector, uh, payment of wages, there is a huge difference. uh, for men versus women. This difference is not there in the public employment, because it cannot be. It is not there for responsible organizations, responsible public private organizations also. But the huge unorganized sector, there is a huge disparity, and that disparity will only go uh, till we stop accepting it. I think we need to have zero tolerance uh, for having I mean, it's you and me, it's people like me, you and me, it's citizens of our country who are running those unorganized sectors and giving lesser wages to women. Things are changing because the law mandates complete equality. In fact, it's an offense under the Minimum Wages Act. It's an offense if you're found to be paying lower wages to women if she's carrying out the same work. But then you're right, the disparity exists, but I think the disparity will exist till the time we really have a attitude of zero tolerance and start from our homes.
The next question is from Abhinav Dikshit. He says, Ma'am, there are arguments against increased punishment for offenders convicted of rape and similar crimes on grounds that it will increase chances of victim survival. Various data suggests that there has been a little drop in actual number of crimes committed even after the stricter laws were in place. Do you think our mindset for retributive justice is stopping us from achieving long-term results? Also, what could be done to mend this?
So our punishment theory is not just retributive. Our punishment theory is actually an amalgamation of five theories. And you are right. In recent times, we have seen that in some of the, especially the sexual offenses against women and children, the sentences have become harsher. Um, See, there is a there, it cannot be. It cannot be completely undone that a harsher punishment is a deterrence for others. It is not retribution alone from the offender, but as a deterrence to the society, as making an example out of the offender for the society is what is an important parameter. But there cannot be a single solution or a one size fit all solution for everything. uh, Mere laws are not enough, that we have seen. Harshness of the punishment alone is not enough. Our basic problems, Abhinav, are at the level of implementation and law enforcement. So I strongly believe that in our country, uh, a person who's committing an offense, he's not thinking how this offense is defined in the penal provision or the penal law, how it is going to be sentenced, or what is the amended sentence under the new law. No, he doesn't care. All that he's thinking, the offender at the time of committing the offense, is that I'm going to not get caught, or I'm going to get away with it. So this feeling of not being able to be able to get away with it, or not being caught, is the feeling that gives the offender the impunity to go on with something uh, that is so strongly prescribed as a very heinous offense. That is a huge lacuna which has to start. I mean, there's a huge problem of police reforms. We can be sitting here and criticizing our police as much as we like, but the fact is that our police also has not been empowered enough uh, to really deal with the offenses in the manner that they could. So whether it is you and I use more science and technology in our day to day lives, but it's the same beat constable who has to do the round, the shifting, and he has to do the evidence collection. There is very little investigation expertise that is given. That the Prakash Singh judgment, Supreme Court very clearly laid down guidelines for segregation of investigation and the policing jobs, but it has not happened. I mean, we have our own set of problems as a developing world of lack of infrastructure. But this is a gap, huge lacuna, which is actually setting us back to a great level. And I think the biggest gap is at the level of the law enforcement level, not at the level of trial and punishment, because and the initial levels at the judiciary also, because it takes forever. So till that is plugged up, there is very little that effective laws or higher sentence will be able to achieve, is what I feel.
Harshita Yadav asks your suggestions, your views on the Sabrimala judgment.
Well, Sabrimala judgment is now up for a review. The larger bench has raised more issues and left it to a seven judges bench. But I, I for myself believe that if there are women devotees who are within that age group which is barred from going to Sabrimala, if those women devotees want to go, then there should not be anybody stopping them. We have seen, Sakshi, it's interesting whenever these women, gender, other gender barriers are defended, similar kind of arguments are raised. Oh, it is a strong belief and it is going to play havoc with the culture and the belief system, and it's going to shake up everything. Sati pratha, I mean, today we can't even think of it. It's not prevalent in our society anymore. But 200 years back, when Raja Ram Mohan Rai started that social movement against sati pratha, he was taken as somebody who was doing wrong, because it was the done thing, it was the accepted thing. It was what started off as women, when men were going to war and there was no likelihood of surviving, or the option was between being ravaged by the invaders who were coming to plunder, after everything was gone. Giving up your life voluntarily like that converted into a sati pratha, and it was felt, the social belief was that the woman does not have a right to have her life after the husband dies. So you hear very interesting, very interesting kind of arguments whenever it is about whether it was 200 years back on that issue, or granting command positions or equal opportunities of permanent commission to women army officers and naval officers. You hear the same kind of issues, but ultimately the issue is of mindset. So I am strongly for the judgment.
That's great, ma'am. Next question we have from Abhidoy. He says, ma'am, as you have previously mentioned in other interviews and lectures, that even still arguments from sides have talked about lesser mental capabilities, endurance, and workers of women to defend the stance. What have you seen as the Supreme Court stance on such arguments?
Great. Amazing. It's you have seen, you must read that judgment of Babita Punia, which is the army judgment, and Annie Nagaraj, which is the navy judgment. Both are, the bench is the same, of Justice Chandrachud and Justice Rastogi. You should read those judgments, and you will see that emphatically it has been thrown out. In fact, the Supreme Court goes on to say that whenever the parity issues are raised uh, across centuries on various platforms for women, then it is the same kind of arguments. And it's, in fact, we use some judgments from other jurisdictions also. So we took out judgments from the Israel Supreme Court, from Canadian Supreme Court, from the US Supreme Court, Australian courts. And it was very interesting because there also women had fought this battle of parity in armed forces. And they had been denied of small things, that we don't have enough. If a country like Israel said that they did not have enough resources to send women also for training, and so that's why. And it's such a small country. I mean, it's today Israel is respected as one of the best countries, in combat. The way they are surrounded by hostilities from all sides, there is conscription in that country. Men and women all have to enroll, because it's a very small population. Everyone has to serve. But even there, we found a judgment where it was said that, well, we don't have enough resources. So the Supreme Court there also said, well, if you have enough resources for men, you better have enough resources for women also. You can't be doing this. Or in America, where it was said that taking orders from a woman. Heaven forbid. That's the kind of expression that was used. So it's the gender battles and gender issues have remained the same. Supreme Court also gets, though Supreme Court has been on the forefront of gender justice from the beginning, but the maturity for Supreme Court also comes with us. There's a very interesting line in one of the judgments that fundamental rights are like empty vessels. Every generation has to fill in those empty vessels with its own wisdom. Now, why I'm saying this is the same provision of adultery, which Supreme Court struck down this time, 4 years back, by a constitution bench to say that this treats women as property of men and chattel of men. The same provision came up for consideration at least on three earlier occasions, in the 60s, in the 70s, and the Supreme Court, the very same Supreme Court, in fact, father of, in one of the cases, father of the author of the judgment this time, who was on the bench then, they found nothing wrong with that section at that time. Well, different times, but then this time changes, and the laws, the Supreme Court will also be a reflection of the time. We don't have a concept of static law. Even our constitution is a dynamic, living document, and that is how it is interpreted to keep pace with life. So ultimately, there's a saying that we get what we deserve. So it's up to us what we really want to deserve.
I mean, the same line, we can say that sooner we will have judgment or decision on the marital rape also. We can say that.
See, that is a perfect world to exist in. But we can't really go on to, I mean, if we want to go on the rooftop, we have to go through the flight of stairs. I firmly believe that, we can't fast track many of these steps. Some things can be fast tracked, but some things have to take their time. Sakshi, there is a principle which is called a mischief principle. Whenever a law has to be interpreted, mischief principle is one of the very important principles where the courts find out what was the mischief which the legislator wanted to curb. That, what was the mischief why this law had to be brought into force. Now, that mischief in a case of marital rape is that women living in abusive marriages, women continuing to suffer really, derogatory and harassing and harrowing and shattering marriages. But do you think women continue to live in these marriages because marital rape is not an offense under IPC? No. If you will see, the reality is women continue to live in these harrowing, harassing, stifling marriages because of either economic reasons, which is a very big reason, or social pressures. So if you're going to have an offense prescribed, it's not like marital rape is not actionable today. It is actionable as a civil wrong. It is actionable as a matrimonial wrong. It is now also actionable under a hybrid law of domestic violence, which is partly civil and partly criminal. So it is actionable there as a hybrid civil criminal remedy. It is not a penal offense under the IPC, but it is a wrong today as a civil wrong, as a matrimonial wrong, as a partially criminal wrong. So women do have that choice of exercising that option. But if we have marital rape, I'm just sharing my belief and my thoughts. I feel that if we will have that, marital rape as an offense prescribed under the IPC, it is going to shake up our matrimonial system far more than the remedy that it will allow to the women to get out of these marriages. We have to ensure that there is economic independence, and the social taboos for women wanting to work out of abusive marriages has to be zero.
The next question we have from Rishi Kumar. The Apex Court stated that Sabrimala's tradition of interdicting women during their menstrual cycle is unconstitutional. What's your stance on this, and is the celibacy argument constitutionally valid?
Well, I have already made I've told you what my personal opinion is. Uh, But I must also tell you that the religious rights which are there in our constitution, specifically Article 25, 26, 27, these rights are also firmly protected as 25 to 28, firmly protected as fundamental rights. But there is a difference. These fundamental rights, so religious beliefs are protected for all citizens. But what is important to see is that Article 25 starts uh, with a clause that which is subject to any other provisions of this part. That is something we often forget when we want to say that religion is our fundamental right. We saw that triple talaq practice was considered to be a religious practice, and it was struck down. So Article 25 starts as subject to public order, morality, and health, and to other provisions of this part. So the religious rights are not in isolation. They are subject to other provisions of part 3 of the constitution, which is the rest of the fundamental rights. But let's see, it will be an interesting argument now that the 7 judges bench is seized of this matter, and now that other issues have been brought in, uh, where also there are gender issues specifically in other religious practices. It will be interesting. Female genital mutilation issue or equal property issue. Let's see. The debate is always good for a mature democracy.
Yes, ma'am, surely. The next question we have from Yakub Alam. In Air India vs. Nargesh Mirza, Supreme Court upheld a constitutional challenge to a regulation that permitted different pay and promotion between male and female in flight cabin crew. Nargesh's judgment was based on the reasoning that Constitution allows differential treatment on the basis of nature's differences, and it wouldn't be discrimination. What did you think of this reasoning?
Well, Nargesh Mirza's case was landmark for one reason, that it held it to be unconstitutional, the practice of the policy of Air India to terminate the employment of women when they became mothers, or when they became pregnant. You are right, it did not go the full circle. It did not achieve everything that was before the court at that point, and it did fall short on that aspect. But again, Nargesh Mirza was a judgment of 1981. A lot of water has passed since then, and like I mentioned, empty vessels, we have to fill it with our wisdom. Times have gone way ahead after that, and today the law of Supreme Court has is of equal rights for men, women, and even the third gender. It's not just recognizing women and their rights at par with men, but now even the third gender has been recognized. So it has been a progress, um, and I think we should celebrate the progress that we have made.
The next question is from Nishtha. She says, "Ma'am, what are your views on menstrual leave policy? The counter view suggests that such a policy creates even more discrimination at workplace."
Well, so do the child leave policies and the maternity leave policies. It's not a. It's important for us to talk about the menstrual cycle, because it is a natural biological process that happens with every woman. And B, it may not be that every woman needs to take that leave, but that opportunity has to be available for women. I think it's important for that opportunity to be available to women who really need it, and do feel the need to take the leave, instead of them making excuses to take that leave if that is available to them. And it's not like a hugely discriminatory, or it's going to create a disparity. I mean, what all that is contemplated is some 10 days in a year or something like that is contemplated. So if that is what the law is looking at, why not? We have to go the extra length for women. We have to continue to do that till one half of the population of our nation, of our societies, are able to come out and realize their potential, their dreams. And I'm not saying everyone has to become uh, an army officer or everyone has to become a lawyer. No, it is every man also doesn't want to become an army officer or a lawyer, or it's about realizing her aspiration. And it is not she achieving something for herself. It is about she contributing to the family, to the society, to the nation. If one half of the population is not able to contribute to the nation to the best of her capacity, what a huge colossal loss to the humanity we are causing. So we have to go the extra mile till we have true representation in equal measures, in equal sense, to the ratio of the population of women. So these affirmative actions are not going to be hurting anyone. I don't think there should be so much of resistance to them.
Next question is from Shivangi. She asks, "Ma'am, what according to you is the strongest argument against different legal age of marriage for women and men, and what is the way forward?"
Shivangi, this is something that we heard our prime minister speaking from the ramparts of the Red Fort this time.
Yes.
This has been a huge disparity, and this has been a cause of contemplation for the policymakers. And if the head of our country, the honorable prime minister from the ramparts of the Red Fort, has chosen to speak about this, that there is a contemplation going on with regard to thing, I think that's a very positive step. Because uh, you know so the law has to be there to ensure that the that people know that this is the right thing to do. But ultimately, if you see that even this age of 18 years, which is currently prescribed as a minimum age, that is also there's a lot of violation to that also. If you go in the heartlands of our country, still it is very prevalent to have child marriages. So this is one of those areas that we as citizens and society need to come forward to bridge that gap. That gap is not going to be bridged on its own. The law is going to be there. We can't have sometimes it was suggested that we should have these marriages as declared illegal. That would have been throwing the baby out with the bathwater, because ultimately, if you make these marriages illegal, women who are in these marriages are going to suffer more. So it's a very complicated and a sensitive issue. It needs to be addressed properly. uh, but uh, but the reproductive rights of women, you should know that 2 years back there was a judgment, Independent Thought versus Union of India, in which a bench of Justice Madan Lokur and Justice Deepak Gupta uh, declared that disparity in section 375 of IPC, which allowed where one of the exceptions was a sexual intercourse with a man with his wife, if the wife was not below 16 years of age. They held that disparity to be unconstitutional. They said no, the the legal age for marriage is 18 years, and when the age for a child is 18 years, then why should this there be an exception for a wife? So they remove that exception. But these are battles that need to be uh, waged on, not just by law but by all of us together.
The second last question we have from Nisha. She asks, "What are your thoughts and about the division of school on the basis of sex? Like it creates a stigma for girls and boys from a young age. It is only when the children go to college. They're fearful to even talk about, especially for girls. It acts as an obstacle for the professional life."
See, girls only schools, boys only schools, and co-educational schools are a reality everywhere in the world. I don't think uh, there is any discrimination there, because it's not like they don't have interaction um with the other gender. Uh, I don't think as a lawyer I need to comment on it. This is something that's in the realm of the educationists, and if they have felt it proper to have it, and it is something that it doesn't take away any rights. Um, I'm not the right person to say if it creates any personality flaws in people. if they come from there are enough and more people coming out of both kinds of education systems and both kind of schools who have done very well in their life. So I'm not the right person, I think, to comment more on this.
The last question we have from Rishi. He asks in reference to Article 14, ma'am, there are special laws made for the purpose of safeguarding women's rights, but why are there no laws to safeguard the rights of the men? Isn't it unconstitutional?
Rishi, wait. Slowly, the world is changing. Once one half of the population is there in all spaces that it in the manner that it ought to be, you know, uh, essentially this is like a power equation. If you see the United Nations definition of crimes against women, is also that it originates from centuries of unequal power relationship between men and women. So if you're driving, if your vehicle or car is going left, you want to make it go straight, then you have to make it go right to actually bring it to the straight line. If it's going left, and if you keep it on a straight line, it will continue to go left. It's not going to correct. For correcting a left going vehicle, you will have to bring it to right, and once you have brought it to right enough, then when it comes to the center, you keep it at center. Wait for our nations, in fact, not just our nation. This is a battle that's there across the globe. So wait for this correction to happen. Right now it has been left for a long time. Allow it to correct for some time, allow it to go right for some time, and once it comes to the center, and equal number of women are there as um, to say it in a lighter vein, as offenders of crime and not just victims of crime, then we will have equal laws. Have you ever heard of a son-in-law being burnt in a matrimonial home or a in-laws home? Or for that matter, have you ever heard of a mother-in-law being burnt in a kitchen? No. This is not a thing that happens to mother-in-laws or father-in-laws or husbands or even sisters. This is a specific mischief that used to happen to daughter in laws and younger daughter in laws in the initial years of marriage. That is why that protection is there for 7 years. That is why that onus of proof does not shift after 7 years of marriage. Let the autocorrect happen. Let the world come to a equilibrium, and then we will talk about true equality.
I think this question puts a perfect end to the today's session that we need to be patient for the rights of both women and men. So Rishi has one more view. So it's constitution in accordance to your opinion.
Yes, I already explained that, Rishi. Constitution allows affirmative action, and that is precisely for the reason that I explained. Things will change. In a perfect world, why should rape? Sakshi said that marital rape. Why should rape be a gender specific offense at all? Why should sexual harassment be a gender specific offense at all? These should there should be no barrier. They should not be bound in gender. Maybe we should have a gender neutral neutrality about these. But we need to reach there to really to have that. Till we reach there, this is a march that we are all going to have to make.
Yes. Thank you so much, ma'am, for being here and giving us such a special time for us for this discussion. We hope to host you on a campus as soon as the conditions are normal. Thank you so much for the session, and I thank all the participants for joining us for the session today. Thank you
Thank
so
you
much.
so much, Sakshi, and to your participants. It was really, indeed, a great evening for me. Thank you for asking me such uh, telling questions and expressing your thoughts and opinions with me. And I wish you all the best in your future and the careers ahead. Thank you very much.
Thank you so much, ma'am.